Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Always down and ready to ride.
Hello, my friends. I hope everybody's well today. I have been so busy this week. I apologize for that. But I hope that everybody's doing well. We do have what I think is a new judge. I don't know if we've covered her before. Careful what you say, Paisley. I don't know. I don't want to jinx it, but the internet seems to be working a little bit better today than it did yesterday. But again, I don't want to jinx it. I also shuffled a few things around. But again, I don't want to jinx it. Sashina's here. Sashina, I got to tell you something. I was, as I am, as part of my job, perusing YouTube. I love that part of my job. And I got, I watch a lot of weird channels. And one of those channels that I like to watch is this like plane spotting channel for LAX. And the guy does like streams every day. And he like basically calls all the planes like a sports announcer. He'll be like, we have Lufthansa, blah, 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 coming up. They are taking off to go here. And he's got like bots set up in the chat that post the next departures at LAX. Like it is a well-oiled machine. Well-oiled machine. Looks amazing. I admire it. I admire the thousands of people that watch the live stream every day. He has a lot of really dedicated mods. But what struck me today was somebody getting reprimanded, which we all know I am a defiant girl. So as soon as like I saw somebody getting told off by a mod, I was immediately intrigued as to like what rule did they break? You know, what's going on? And their rule there was that only mods are allowed to use the commands. Okay. What? That's just not how that works. I don't know how you enforce that. I guess they enforce that by just deleting people's comments and then reprimanding them publicly and then kicking them if they don't listen. It strikes me as odd. Then I sat here and I thought, well, is that how it's supposed to be? Have I just sort of assumed that? I mean, I think our command game is pretty on point around here. We have a lot of fun commands and everybody can use the commands if you remember them. But I mean, that's the caveat for everybody. Do we remember them? Right? But I don't gatekeep commands. Actually, that's not true. Hold on. Dumbass Paisley. Hold on. They can set that up. I just remembered. In the settings, you can set that up. Because there are certain commands. Oh, what did I do? I think what I did was I made med check. When I first was administrating the commands, I was in charge of them. Now it is lovely for Jonathan Sashina and for some reason I'm going to say Sashimi. Sashina and Miss Carrie so far to be doing the mod thing, and they add them. So I don't really look at them, to be honest with you. Anyways, but med check, I think I made it. You can only do once every like hour. I don't know. But I remember now there's a drop down where you could say who could do them. So to me, it seems like maybe they're just using it wrong. Like if you don't want people to be able to do that command, you shouldn't really have that command. Right? Huh? Right? Thanks, Gecko Chaser. I love the hat too. It's my Florida hat. And I miss Florida. We are not going to Florida for court today, but we are going to a fancy lady court. This lady is a fancy lady. Whoa, hello, lady.
Yes, Your Honor, we're ready.
Now I got
This is on Rule 9 here.
Hold on. Is it hat day? Yes. Always hat day. I got to dip out while this starts. Otherwise, it's a little bit jerky. But this is, I need you guys to pay attention for me. Brian and Kimmy are here. Hey, Brian and Kimmy. I need you guys to pay attention. I believe the judge has some sort of filter on her box. And I'm not talking about a merkin. I'm talking about her like Zoom box has pink in the bottom, and at first I thought, oh my god, she has pink accents on her robes, but I don't think that's what it is. Sashina, done lambing, lamb number 12 this morning. Excellent. Lovely. Also done lambing at my house, got 0. To be expected. Just wanted to say that as well.
On behalf of defense.
Great. And call your first client.
If the individual in this query can identify themselves.
Yes, Lamar Cooper.
Okay, Your Honor, this is Mr. Cooper. We have 2 cause numbers before us today. I will read them off. It's cases 23L001618 and 24L000626.
Okay. And your true and correct name is Kenneth Lamar Cooper.
Yes,
Your date of birth is March 11th of 1958.
correct.
And do you reside or receive mail at the Boston Avenue Southwest Apartment B1?
Yes,
Okay. And did you have an opportunity to review with the attorney the rights that attach at arraignment?
yes.
Do you have any question about the rights that attach at
No.
arraignment?
No.
Okay. And is the public defender is acting as a friend of the court in your defense, unless you qualify, and then she'll be directly appointed. So I'll turn it over to defense attorney at this point for entry of plea. There we go. Thank you.
Your Honor, we, on both matters that we have for arraignment, for Mr. Cooper, we will be stipulating to probable cause for the purposes of today's hearing only, and we will be entering into pleas of not guilty on both matters. I explained to Mr. Cooper the charges against him, and he acknowledges and understands those charges as well as the penalties associated with them. At this time, Mr. Cooper qualifies for the appointment of a public defender to his matter with no promissory note, so I will be asking for appointment.
Okay. All right. I will directly appoint. And for some reason I'm seeing, it looks like as far as jabs, they're both on for arraignment, but only one is showing on the court order. Give me just a moment. I'm just going to give us a moment, Mr. Cooper. I'm going to make sure that the documents are. Okay. I was. Okay, great. I'm out. We're just going to have a new form.
That's what she said. I'm out. I'm out.
Uploaded.
Sounds good, Your Honor. I believe I see an order for competency evaluation, but I believe that's something the city's uploaded, so I'll let them speak on that before I make any record.
Okay. Is there a competency concern?
Yes, Your Honor. I've spoken with the alleged victim this morning, Ms. Upshaw. She has expressed that she is well aware of Mr. Cooper's mental conditions, and she says that this is a result of his military service and that it's well documented in his military medical files. It does not appear Ms. Upshaw was aware of the no contact order that was put into place in a concurrent assault 2 matter, where I saw that the county court has also requested a competency evaluation. And so at this time, in speaking with the AV, I do believe that she is well aware of her situation. She does not feel threatened by Mr. Cooper. And it would be appropriate to release him without requesting an additional no contact order. I am requesting an out of custody mental evaluation based on what Ms. Upshaw has said to me about his mental conditions. And I've made a note in there, Your Honor, that if the evaluation from the county is completed before the one that I am requesting, that the city could adopt the Superior Court's evaluation.
All right. Does defense have a position on that?
Your Honor, at this time, based off of my conversation with Mr. Cooper, he did seem to present to me that he understands what's going on in his cases today. But as it is an out of custody evaluation, I would not have an objection to that.
All right. Well, then we will, so basically what the city is asking, because I understand the mental health component and then there's a competency component, okay? And so to me, it's sounding a little bit more like there's a concern about a mental health component and perhaps that kind of evaluation, some kind of mental health request is the concern of the city versus competency. But you're also saying that the Superior Court has ordered a competency evaluation. So I'm a little confused because it sounds like council didn't have any trouble communicating. And if we order the competency evaluation, then what we're doing is we're tolling speedy trial. So that's my concern, is without defense supporting the idea that he can't assist in his own defense and then delaying speedy trial, there's just a constitutional concern with that.
Understood.
So at this point, I'm hesitant to toll speedy trial because that's automatically what would happen under the competency evaluation. However, what I'm going to submit to the parties is if we will set him for, and I'm going to proceed with an arraignment today on his matters. If the parties follow the Superior Court competency and see that that has come back incompetent, that perhaps at that point, that would be enough evidence to present to the court that there should be a concern, but without the lawyer having the concern and also disenfranchising him on the constitutional basis, I'm just hesitant to do that because of the tolling of speedy trial and how important that constitutional right is to have the speedy trial. So does anybody have any questions about the court's concerns?
No, Your Honor.
Okay. And so, but should there arise new concerns either from defense counsel or presented by way of the other competency evaluation, then, and if it's me, of course, I'm happy to address, but I'm also making a ruling for the record that the city's entitled to readdress this matter. Should anything else arise, because I don't want them to be precluded from arguing that if that is a legitimate concern. Okay. So I'm just going to defer that at this time.
I do have one concern. If there is already a current competency evaluation pending, does that, and I can check with my supervisor, she's logging on, does that impact any future, new arraignments is basically what I'm trying to say.
No, at this point, every case is stands on its own 2 feet. So at this point, your representation that you had no problem communicating with him and you feel that he can assist in his own defense and that he understands what's going on is adequate for this hearing for him to be arraigned. Okay, that does not mean that there won't be other evidence later, but at this point, the court does not have enough evidence to weigh on the side of limiting his constitutional right for a speedy trial.
Understood, Your Honor.
Okay, all right. So at this point, you represented that he would, you do believe he would qualify for the public defender, so I'll do a direct appointment on that. And probable cause was previously established on the hit and run. Let's see, on the protection order violation. That was just from recently. And so is there a stipulation of probable cause for purposes of setting conditions on the protection order violation?
Yes, Your Honor.
Okay, I'll enter that stipulation and I'll hear from the city on conditions of release.
And Your Honor, once again, in our conversation with the AV this morning, we feel confident that there is no risk in releasing Mr. Cooper. And the alleged victim seems very aware of his conditions and dealing with them.
Okay. All right. So I will order his release. Sir, you're going to be released on your promise to appear at all your court hearings, have no criminal law violations, update your address if it changes, and use your true and legal name and date of birth. Any question about those conditions of release, sir?
No.
Okay. I'm going to set a pretrial conference. Hesitant to set it out to the May date, which is the first date I'm given, because that's quite a ways out. So let me see here.
I don't know what lip
Is this a
stain-
complicated?
I know she's wearing a lip stain. Tin Man, can you identify the color of her lip stain? I can tell it's a lip stain because she's not like smacking her lips the way that I do when I wear lipstick. But when you wear that lip stain, it's got that really good color and saturation. You see how saturated it is? Also, pink is obviously this lady's color. I think whoever said that might be flowers in front of her, that might be right. I was thinking, did she have some Zoom filter that she's got put on here? You think they're cranberries? Oh, maybe. I will buy every lip stain color there is to find out and keep on trying them all. She'd be passionate around. Is it more permanent? Yeah, it lasts about 24 hours. Here's the thing though. At about 20 hours, it looks pretty fucked up. I'll tell you that. Like the outside part of your lips is still stained, but the inner part of your lips has no stain in it. And yeah, that's when I've gotten the weirdest, like sometimes I'll take a phone call and it'll be approximately 20 hours after I've put on lip stain, like a video phone call, and I'll catch a glimpse of my own lips and it looks like an infected butthole. I'm just joking. That's a terrible way to put that. No, you don't reapply. You apply one time and then you you don't smack your lips when you apply. That's the hardest part for me to get. Apply. Oh yeah, let's watch some Big Booty Starfish. Fair enough. Good name though. Let's watch them.
From defense perspective?
I'm not sure what you mean by that, Your Honor. Regarding a judge?
It's okay. Yep. There was no, I don't think anything's been filed. So you're not aware, correct?
No, nothing that I'm aware of.
Great. Of the attorneys.
No, Your Honor.
If parties can please sign. Sir, you're going to be released today and I'll order you be given a copy of your court order that has your attorney's contact information, your conditions, and your next court date. If you have questions about any of that, or if you're released and you lose your paperwork, you just call the Lakewood Municipal Court. They can give you all the information again, okay?
Okay.
All right, wish you a good day, sir.
Your
Thank you.
Honor, the document hasn't been marked for defendant released under their own recognizance.
Yep.
Thank you.
All right. What? Yep. All right, what's your name, please?
Alden Tucker?
Alden Guzman Tucker,
Yes, ma'am.
and that's your true and correct name?
Yes, ma'am.
All right, and I'm just going to confirm that your date of birth is there we go, September 20th of 1983?
Yes, ma'am.
All right, and do you still reside or receive mail on the Jason Court address in Lacey?
No, it is 4404. Southeast Lacey, Washington, 98503.
That was 4044?
4404.
4404, okay, 4404, Avonlea Drive Southwest in Lacey?
Yes, ma'am.
Got it. All right, and did you have an opportunity to speak with the attorney about the rights that attach at arraignment?
Yes, ma'am, I did.
Did you have any questions for the court about your constitutional rights?
No, ma'am.
Okay, and I'll turn it over to defense for entry of plea.
Your Honor, this is Mr. Tucker, cause number 22D000039. This is a matter of operating vehicle without ignition interlock from 2022. Today we will be stipulating to probable cause for the purposes of today's hearing only, and we will be entering a plea of not guilty on this matter. Mr. Tucker qualifies for the appointment of a public defender to his matter with no promissory notes. I will be asking for appointment as well.
Okay, I've directly appointed the public defender. Looks like a warrant was previously issued, so probable cause isn't an issue. Sir, now I'm going to turn to the prosecutor, get their recommendation on conditions of release, and then I'll allow your attorney to respond, okay?
Yes, ma'am.
City?
Your Honor, the city is not requesting bail in this matter. We are requesting that Mr. Tucker do not operate a vehicle without the required ignition interlock device. We're also requesting he have no alcohol-related violations. And we would also like to request his next appearance be required under Rule 3.4.
Okay. Defense?
No objections to that, Your Honor.
All right, I'll set you for an out of custody hearing on May 28th at 1 p.m. That will be at the Lakewood Municipal Court. Do you know where that is, sir?
Yes, ma'am.
Okay, and that will be an in-person hearing necessary because we're last seeing you in custody. I'm going to release you on these conditions. You promise to appear at all your court dates, have no criminal law violations.
Same conditions, Chris. You can't have any criminal law violations. I'm sorry you're not doing well. Thank you. Can we send some good vibes to Chris? This week has been a fucked up week, my friend. I tell you that. Did he say Rule 34? We know what Rule 34 is, though, around here. Rule 34, oh my God. I'm not even going to say it. I'm not even going to say it. You are a gem, Chris. A known gifter. And not only that, a great friend. And even if you didn't gift anymore and you just hung out, that's all we need. Because we love hanging out with you, Chris. Remember that. CRD is here, shoveling food into your cake hole. For a moment, I was worried that you were somewhere that it snowed. And then I thought, wait, finish reading. And then I did. Love it. Can't get enough of it. Does Rule 34 apply to kitchen court chats? Yeah, it does. Of course it does. It applies to everything. And here's the crazier part. No, I'm not even going to give anybody a little nugget to follow there. Let's just watch this.
Update your address if it changes. Use your true and legal name and date of birth. No alcohol-related infractions. And you're going to comply with the Department of Licensing rules and requirements regarding the installation and use of the ignition interlock device. Do you understand those conditions of release, sir?
Yes, ma'am.
I also will order you will be given a copy of this court order, which will include your attorney's contact information, all the conditions I just discussed, and your next court date. Okay?
Yes, ma'am.
Any questions about your arraignment?
No, ma'am.
Anything further from either of the attorneys?
No, Your Honor.
Parties want to review and sign. And then once they've signed, like I said, sir, I'll order that you be given a copy of your court order and you'll be released today. Okay?
Yes, ma'am.
Wish you the best of luck, sir.
Thank you.
All right. Sit on that matter. Thank you, sir. You're free to go.
Oh, I leave.
Thank
Sorry.
you. No problem.
You didn't know to leave. That was cute. I don't think she has an OnlyFans. Judges get paid pretty good. Especially if they moonlight as lawyers still.
Hi there. What's your name, please?
Michelle Atkins.
Oh, how old do we think she is, you guys? We can guess the crime and her age. Let's figure it out. Okay, it's time to guess the crime and her age. I think that she is in for stealing from Home Depot. And I believe that she is 32. 32 years old. Oh, Lisa B, 43 in theft. Mid-30s, theft. 32 going on 60. 48 in shoplifting. Meth, 34. Hard 34. Hard 27, Brian and Kimmy. Oh, the drugs. Well, that's the calculation that you have to do here. That's the physics that we have to deal with. Complicated math. Murder cat husband, I like it. All right. Let's go ahead and no more bad. And let's watch it.
Michelle Cherie Atkins.
Yes.
And that's your true and correct name?
Yes.
And your date of birth is February 27th of 1986?
Yes.
Shit. Oh shit. So 1986, she is 38 years old. 38 years old. Lisa B, ask and you shall receive. And Cellulite Yoga Pants. YouTube Daddy has been punishing all of us YouTubers with no notifications. Just absolutely terrible with notifications this week. For 38 years old, so she's 2 years older than me. What does that say about me or her is really the question. And not the judge, but the judge is older than that, right? Hold on, let me get the girl up here. Courtney!
And I'm just going to confirm that you reside or receive mail at the 47.
Oh, Judge, can you fucking not, please? You know, I don't like having to fucking censor you here, but you don't need to be putting her address. And it's not him. Hold on, where is it? Ugh.
Thank you.
Left. Here we
No
go.
problem.
Michelle. Well, that's very kind.
Hi there. What's your name, please?
Michelle Atkins.
Michelle Atkins. I mean, to be fair, actually, I have way more gray hair than she does, which is why I'm wearing a hat. But she does look like well, I don't know. I'm not gonna lie and say that I've lived the easiest life, but I definitely haven't lived that life. Thank goodness. Knock on some wood. Chris Engelby, look what you're doing. Bringing joy to everybody. You're so sweet. Do 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 do. And this is secretly why I do these shows. I'm like, oh my God, look at how that lady is. She's so possession with intent. Yeah, did we hear what she did? I have no name. You could probably. America lets you do amazing things. Make sure to turn on gifting. Tomorrow is a members only. I already have 2 videos for us to watch. They're good. Okay, get off the screen, Kisley. This isn't about you. It's about Michelle, okay? But thank you, Chris. We love you. Bye. Be well.
Michelle Cherie Atkins,
Yes.
and that's your true and correct name?
Yes.
And your date of birth is February 27th of 1986?
Yes.
And I'm just going to confirm that you reside or reside. Okay, great. And did you review with the attorney the constitutional rights that attach at arraignment?
Yes, ma'am.
Did you have any questions for the court about those rights?
No, ma'am.
Okay. And I'm going to turn it over to the defense attorney for entry of plea for your charges.
Your Honor, this is Ms. Adkins, cause number 24L000624. This is a matter up for arraignment. I've gone over the charges. Ms. Atkins understands the charges and the penalties of those charges against her today. We will be stipulating to probable cause for the purposes of today's hearing only and entering into a plea of not guilty. Ms. Atkins qualifies for the appointment of a public defender to her matter with no promissory notes. I will be asking for appointment today.
Okay, thank you. I'll enter the not guilty plea. I'll directly appoint the public defender and enter a stipulation to probable cause. Ma'am, now I'm going to turn to the prosecutor for their recommendation for conditions of release, and then I'll allow your attorney to respond. City?
Your Honor, the city is not requesting bail in this matter. We have not been able to reach the alleged victim in this case, and based on Ms. Atkins' limited history, this being her first criminal violation, we feel confident that your release would be appropriate. We do not believe that an NCO is required at this time. We are going to just request standard law-abiding behavior. I believe that is all, Your Honor.
Okay, thank you. Defense?
No objections to that, Your Honor.
All right. So ma'am, you'll be released today on your promise to appear at all your court dates, have no criminal law violations, update your address if it changes, and use your true and correct name and date of birth. Any questions about those conditions?
No, ma'am, not at all.
And your next court date will be May 28th at 1 p.m. That'll be at the Lakewood Municipal Court. Do you know where Lakewood Municipal Court is?
Yes, ma'am.
Okay, great. I'll order that you receive paperwork with your conditions of release, your next court date, and your attorney's contact information. If for some reason you lose that paperwork or you don't get it upon release, you just call or stop by the Lakewood Municipal Court during office hours. They can give you all.
They waive the reading of the crime, it sounds like, but we can assume it's something assaultive with a victim that they're trying to get a hold of. Most likely. Sometimes they do, sometimes they don't. I'm not in charge of this court. Can't you tell this lady's in charge of this court? She has nice earrings. Also, I don't pre-watch these. That would be incredibly boring for both of us.
All that information again, okay?
I do have one question.
Okay.
I'm on her phone plan and I don't know if she's gonna turn my phone off or not. So in that case, what do I do if she does?
Ooh, now we can assume it's either a lover or a mother who pays for her phone. Muy interesante. The plot thickens.
Turn my phone off.
Ms. Atkins, you can either get your own phone line or
Oh, okay.
there are other resources that you can look up for a free cell phone if you can't afford one, okay?
Okay, sorry.
No, that's just something the court can't determine for you, so that'll be a discussion you can
Right, okay.
have with your attorney. That's best, all the details that in regards to your case are best discussed with your attorney. In this system, the court is kind of like the referee, making sure everyone plays by the rules, that your rights are protected. But as far as addressing personal issues, that I can't do that, okay?
Okay.
Any other questions for the court that I can't answer?
No.
Okay, anything further?
That might be the nicest way of saying that's a you problem that I've ever heard.
From either of the parties?
Nothing.
Nothing from the
Okay. They're just going to sign the court order and I will sign it and then you'll be free to go, ma'am.
Okay.
Nice. I have all the grays, but I started getting gray when I was like 20 years old. So I'm not
All right.
surprised if I have it.
You're free to go, ma'am. And then we're looking for Angel Santiago Peña because we have the interpreter online.
Yes,
Are
Your Honor,
you
good morning. And for the
fucking
court's record, the
kidding me?
name is Carlo Tarnas, certified for legal Spanish, permanent oath with the administration.
Where the fuck is he appearing from? Some work shed somewhere. Wires hanging everywhere. A lot of things plugged in. A router in view. What in the absolute fuck is going on here? Ugh. This is a court worker. He's the interpreter. As usual, we get an interpreter case. This is a great way to reinforce my stupidity. Took Spanish for 4 years. Can I speak it? No. No comprende.
Leader of the courts.
Okay. Give us just a moment to see if we can get our, the right client for you here in custody. All right. And what's your name, sir?
¿Cómo se llama usted, señor?
This is the Spanish guy? This is the Spanish guy? He sounded like he understood that question. Are you sure you got the right guy? Well, I bet they do, maybe.
Oh, nope, that's Mr. Isn't that Mr. Resnick's case? All right, I'm sorry, is Mr. Resnick online? Oh, he is, okay. So, Mr. Interpreter, you're just gonna have to wait a few minutes. So it looks like they've, okay.
Understood. Standing
I
by.
apologize.
Not a problem.
We'll get to you just as soon as they bring the right client for you. And
Very well.
meanwhile, we will look forward to hearing Mr. Resnick's voice because his client is on. Are you there, Mr. Resnick?
I am, Your Honor. Thank you, Matt Russ. I counsel of record for Mr. Orgy, except for in the new matter. And there's a little bit of background to the court and to the city. I had filed, as the city knows, a motion for a furlough for treatment. That was filed on Tuesday.
Yep, I have it.
Yep, as of yesterday, I fully expected to log on at 11, which I did, and deal with Mr. Orgy and another defendant. Had a haircut scheduled, so I did not see the email until moments before I logged on from the city, their response.
You're telling me that you recently had a haircut and this is the result, sir? Is that a joke? That's a lie. Is the haircut what he calls his wife, or like seeing his mistress? Like, babe, I get my haircut every week, like 3 times a week I get my haircut. You know, I gotta get my haircut. Like, he can't be talking about getting his actual haircut, right? Oh, fuck. Colin, what's up, dude? How you doing? Do you believe that this guy just had a haircut? Everything looks very rounded. He's telling the judge this. I know. Beauty school dropout. He's the lawyer. This is the lawyer. Oh, ridiculous.
Which came to me at 8:04 a.m., along with finding out that just yesterday, and I wasn't aware of this until moments before I logged on also, that a new case had been filed against Mr. Orji. That being said, I did read the city's response, which touches on the allegations, but I think to arraign him, I think I obviously didn't get a chance to go over the rights form with him. I think he needs to be arraigned on the record. Further, I can't stipulate the probable cause. I mean, other than a brief cursory summary in the response to my motion to have him released for furlough, and where Mr. Farrow touches on the allegations in the new matter.
He touches what? Also, hi, CO. Welcome. Is that how I say it? Glad you made it live. Make sure to clock in for your shift. Hit the like button. And this is Mr. Orji's case. Somehow, some way, I find the cases. Oh, the cases.
I haven't actually seen a complaint or a PC statement, so I'm going to actually ask for testimony, or however the court wants to go there on that matter as well. And usually I'm more prepared, but fully had other things I did this morning that didn't involve being in my office, and didn't see this until moments before I actually logged on. But I think we probably need to arraign first before we go into the second matter.
Okay, so just to clarify, we're starting on the arraignment matter 24L000610. And that is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. 13 counts of protection order violation. And so I just.
Oh, no. Oh, that's, oh, dear. CO, that's also hilarious. I love it. That's why gifting memberships is awesome. Jonathan covered a different case with the same case and the same attorney, or the same guy and the same attorney. That's weird. When was it? Cellulite yoga pants. I haven't seen the Jonathan's video. I almost feel bad. I don't have time to watch other people's videos that much. So was this the TPO? Did he cover the TPO? That's interesting. Because I just got this today. This was just yesterday. So, muy interesante. His arraignment, his first arraignment on other matters, because this is his arraignment. Maybe this is it. Like I said, I don't watch them first. But 9 TPO violations, it reminds me, if this was in Thurston or in what is the other Washington court that we do? Not Bellingham, but the B one. Anyways, Bothell. In Bothell, there was a case I covered last year where this guy got his TPO like ankle monitor They put an ankle monitor on, and he was like in an exclusion zone, and they basically allowed him to be released to a church parking lot. And then he was fleeing the state basically and leaving to another state. And the judge, it was a weird case. That's on KCC 1.0. Where are you from in Scotland, Sia? I was born in Glasgow. But I think there's a drink called Squirt, but I prefer Iron Brew. Oh, it's grapefruit soda. Thanks, Donald. Helping us out.
Just to clarify, because I didn't hear every word because we're through Zoom also, and so it's not as clear as in person. Did you say you did go through his constitutional rights with him, or you did not?
I did not. I wasn't even aware until I logged on that he was facing a new charge today. It was just filed yesterday, I presume at the very end of business, because I didn't get anything.
Okay, so, okay, would you like me to give you a breakout room for him to go through his constitutional rights?
That would actually be a good idea, and it'll be fast. Yeah, I mean.
Okay, all right, we're gonna do that. And how do you pronounce your last name, sir?
Orgy or John.
Okay, we're gonna put you in a breakout room with your attorney just so that he can make you aware of the charges, and then we'll proceed. Okay, so if you could join, are you allowed to touch the screen and join it, or does somebody have to do that for you?
She's doing it.
Oh, there we go. Okay. Ooh, wow. Way too big picture of me. Yikes.
Oh my God, Judge, I say that all the time. Bunny, would you change your last name? What is she doing? Just waiting for them to come back? Waiting quite a while.
Well, he's been previously appointed.
There we go. Oh, sir, go back to the 70s.
We are back with Mr. Orgy whenever the court's ready.
We're going to go back on the record. And I think you've also been emailed a copy of the complaint.
Oh, let me take a look. I'm sorry. Let me take
Oh, that's fine. Give you a moment.
Yep, thank you.
And it's also in Zoom,
Okay.
in your chat.
13 protection order violations is no good, though. What did you guys have to
Do we have
eat
Mr.
today? What am I going to eat?
There it is. Yep.
There it
Okay.
is.
Yep. Yep. I will acknowledge receipt of the complaint. Okay.
All right. Okay, so I've confirmed or I'm now confirming. Did you have an opportunity, sir, to go through the rights with the attorney?
Yes, Your Honor.
Yeah, so you understand your constitutional rights. Any questions for the court about your constitutional rights? Okay, and then I'm going to turn it to Mr. Resnack. Do you believe that he would qualify for he's been previously appointed to the public defender, correct? So I'm going to go ahead and do a direct appointment, and then I'll allow you to do an entry of a plea. Go ahead.
Thank you, Your Honor. So that being said, as Mr. Orgy himself confirmed on the record, he does understand the rights he has. We are going to waive further formal reading. I can't, again, really step to probable cause with just the cursory allusion of what the allegations are in the motion to deny my response to the city to deny my motion to release to treatment. I can't really in good conscience stipulate the probable cause. That being said, though, we are still going to waive formal reading, enter plea of not guilty on every count.
Okay, done a direct appointment, entered not guilty pleas on all the counts, and the waiver of formal reading. And so I'm going to swear the city in. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, we'll go ahead and hear a probable cause reading, and then I'll make my determination, and defense can argue or reserve on their arguments. Okay, go ahead, city.
Your Honor, this information comes from police report 241 0001065.1, Officer Molly Yoshikawa with the Lakewood Police Department. On April 9th, 2024, at approximately 12:30 hours, I was performing routine patrol when I was dispatched to an order violation at 5478 Fair Lawn Drive South. The protected party was Natalie Orjai, and the respondent was Devin Orjai. I confirmed with South Sound 911 records that there were 2 no contact orders in place. One from Pierce County Superior Court and 23L001757 was in place by Lakewood Municipal Court. Officer Yoshikawa was provided a screenshot showing 4 calls made between Devin and Natalie on March 12th, 2024 from the Nisqually Jail, as well as 4 calls made on March 14th, 2024 from the Nisqually Jail. An additional list provided, an additional screenshot showing a list of calls made between Devin Orjai and Natalie Orjai shows 6 calls were made on March 21st, 2024. And for a little clarification, Your Honor, this report stems out of Officer Yoshikawa was made aware of violations of calls from the jail in violation of those orders, and then provided screenshots to show the call logs.
Okay. All right. And so that's the probable cause allegation. Does defense want to make an argument or reserve argument?
No reserve.
Okay. All right. So at this point, sir, I do find that there are adequate facts for a finding of probable cause. And so I do find probable cause on all counts at this time for the purposes of setting conditions. All right. And so I'll hear from the city on conditions.
Your Honor, although that Mr. Orjai is currently held, the city is requesting a $10,000 bail in this new matter.
Okay, so total of 10,000 or 10,000 on each count?
10,000 total.
Okay. All right. And then standard conditions of release?
Yes, Your Honor. There are already no contact orders in place.
Great. All right, I'll hear from defense.
Well, and I guess this does dovetail into the motion to release the treatment for the furlough. Obviously, up until now, Mr. Orjai he was serving a sentence. He wasn't held on bail. Notwithstanding that, even if the court, without these new matters, denied the motion, he wouldn't get out of jail anyway until he served out the remainder of the time. That being said, while I understand and I can respect that they can ask for, that the city's going to ask for some kind of a bond, I would ask that anything other than a nominal bond is really going to be something he can't obtain and post. Beyond that as well, if and I don't know whether these allegations are just that or whether there's more to them, and I'm not going to go there, but they are at this point merely allegations. I would suggest that Mr. Orjai is painfully aware that he's under a microscope, and for him to do anything, whether he remains in custody or out of custody, that might even hint at the possibility he's breaking the orders, is probably going to result in yet another series of charges being filed on him in the future, as well as very, very high bonds. So I'm asking the court to impose something like $1,000 bond completely, not 10,000. And if he posts, he understands that, again, to use that metaphor, he's under a microscope, and any violations of conditions of release, and I'm speaking specifically now to contacting the defendant, the witness in any way, would result in extremely high bond next time and a revocation.
And Your Honor, if I may interject, because I haven't run into this situation before, Mr. Orjai is currently held on the other 3 review matters. So I guess I'd like to add that if it's the city's position to hold him in custody to continue serving out that sentence as the city has requested, then we could agree to PR Mr. Orjai on this arraignment matter.
Okay. Okay. So basically what I'm hearing from the city, and I understand, I just want to be clear for the record, is because there's that other pending motion, they're saying if the court is going to grant, so defense is moving to have him released to go to inpatient. If the court denies that request, then the city's okay with the PR release.
Correct,
Is
Your Honor.
that okay? I just want to make sure that I understand it because that's what I understood you to be saying. Okay, so I'm going to reserve on bail for a moment just because we've got the other pending bail argument. So I'm going to reserve on bail for a moment, and I'm going to turn to the standard conditions, which I'll order that you have law-abiding behavior. If you are really, well, even if you remain in custody, no matter where you are, you're to have law-abiding behavior and not have any contact whatsoever with any protected party of any court order, and specifically emphasizing the alleged victim in this case, which should be abundantly clear. And you understand, not only does that subject you to revoke on your current matters and additional conditions on the current matters that can subject you to new allegations. Just to be clear, which I'm pretty certain you already know that. Okay, so turning to the current motion that's before the court. So defense has moved to have defendant released to treatment with day-for-day credit, and then the city is not agreeing to that. So how does defense want to proceed? Do you want to make your pitch one more time? Or how do you want to proceed at this point? You know that the city's disagreeing, but it's your motion, so you can let the court know whatever you want me to know.
Well, this is all new information to me as far as these new charges. Honestly, an hour ago, I wasn't even aware they existed. So that being said, I'm going to stand on the original motion. As far as release to treatment, I would ask that the court consider it strongly, that Mr. Orji get to go to treatment with the understanding that he's going to come back and report to jail if there's any more time at the end of the jail that hasn't been served, irrespective of whether the court grant. I guess it's a two-part motion. If the court just says no release to treatment, the day-for-day credit aspect of the motion is moot. But the court could also meet us halfway, grant the motion to release to court, and say no day-for-day credit. When you're done with your treatment plan, you do have to report back and finish serving out your sentence. That's another option. I would certainly find that preferable to not having Mr. Orji go to treatment if that's one of the issues that's driving the situation here. And certainly without acknowledging the veracity of the new charges and the new allegations. One of the things that people that do have an ongoing long-term substance problem have issues with, and it's hard to parse it out. They think and act like alcoholics, like addicts, whatever, substance dependent people, even when they would pass a UA, even when those substances are not actively coursing through their circulatory system, it takes them a while to get the cobwebs, metaphorically speaking, out of their brain and stop thinking and acting like active alcoholics or active drug users. And I without, again, acknowledging or speaking to, again, the veracity or lack thereof of these new charges, I would submit that even if somebody's in jail, and now I'm speaking hypothetically, and has been in jail long enough that any substance that would impair them as far as a UA goes, it has exited their body. If they're still been in jail only a certain amount of time, a short period of time, they still may have emotional responses and think and behave like an active user or drinker, heavy drinker. Notwithstanding that they're not actually under the influence per se in a legal sense. I think colloquially they call it a dry drunk syndrome. And that being said, Mr. Orji would very much benefit from this treatment.
Okay.
That's it.
Thank you. I'll hear from the city.
And Your Honor, I just want to check really quick if you had an opportunity to read the city's response that was filed by Mr. Farrow.
I read the response.
Okay, so I won't go through that in detail, but essentially the city's concerns are, and with respect to what Mr. Rusnak has just said, we have concerns for the safety of Ms. Orji, who Mr. Farrow has indicated she's fearful of him, and the city's position is that we would like to be in a position to protect her. And so we believe that it would be inappropriate to release Mr. Orji, and we would like him to remain in custody to serve his sentence.
All right, you get the final word, Mr. Resnick, if you want the final word, just because it's your motion.
I'll address the tertiary issue, I guess, at this point of bond on the new matters in a minute. I did speak initially, but I'd like to circle back to that. At this point, I know Mr. Orji would like to get on with his life. Again, it's very hard for the court to parse out a new yet unproved brand new set of allegations versus what's going on in the past, historically pled and proven. But I'm asking the court to do that, to parse it out and focus on the past and grant the motion. Again, if Mr. Orji deviates even in the slightest bit from whatever his conditions of release are, and that includes, if necessary, if the court orders it, returning immediately back to jail after treatment, then he knows he's going to be in jail. He may even be charged with escape third degree or something. Depending upon deviation. I'm sorry. Yeah.
No, I understand. And I understand the complication. And I really appreciate with what you're saying, Mr. Resnick, in regards to the addict brain, because I understand that when we haven't learned the life skills and then we are using drugs or alcohol or anything, can be food, can be anything that we're using as a tool to deal with life. And then we remove that tool, then we haven't replaced it with a healthy tool yet. It's really hard to know how to deal with life. And usually when we're in crisis, repetitive behaviors become part of, and also repetitive thoughts are really daunting. And so I understand what you're saying in regards to that. I also understand the city's perspective of keeping the community safe, keeping Mr. Orji safe from himself, and protecting specifically not just society, but the victim. And so the court has to weigh all those factors. In weighing those factors, one concern the court has is that it's not a secure facility where there could be some of those fears addressed by a secure facility. The other concerns the court has is as of within the last year, all the active warrants, and I understand that might be past behavior, but it's not that old of behavior to still be disconcerting to the court that not only are orders being violated recently, but then also allegations in custody. These are not proven, and I understand what Mr. Resnick's saying regarding isolating those, and I do weigh certain matters differently than other matters because I understand after many years in this system what it means to have a proven case and what it means to have an allegation. It's still required under the court's authority to weigh all these matters with different weights, but still ascertain what the fair and just thing to do is in this type of situation. At this point, a sentence has been rendered. There are pending allegations. There are provable priors, as proven priors, as well as pending priors. There are factual warrants outstanding, which show a tendency to not follow the court's order. And that is fact, not allegation. And so there are enough facts to outweigh the concern I would have about mere allegations in regards to allowing him to serve out his sentence. And that sentence has been ordered. That seems, from my review, a fair sentence given the allegations and the number of allegations and the types of allegations. And so I don't see any reason to readdress that. And consequently, I'm denying but allowing defense to readdress the request for inpatient treatment if new facts and circumstances come to light, or if there, of course, is an agreement of the parties. But I'm denying that request based as well as I can on what I've previously articulated. That being said, it's my understanding that the city is just asking you to abide by the court orders, update your address if it changes, use your true and legal name and date of birth, and appear at all your court dates, and isn't objecting to a PR release on those new matters. Is that correct?
That is correct, Your Honor.
Just to confirm, I know we discussed it, but so what I would do is release on all those new matters, have him serve out his sentence, and then I hope very much that there would be part of, if there's a plea agreement or otherwise, just on his his own, addressing the inpatient opportunity in order to have a shift in whatever's going on there. That being said, I've set the next court date. Let's see. April 26th at 11 a.m., presuming that he'll still be in custody a couple weeks from now. And you may want to meet with your client, talk with him about the new pending charges. And then I've set an out of court date as May 28th at 1 p.m. And that's at Lakewood Municipal Court if you are released.
Could we go to the
The conflict calendar
date?
date. Yeah, sorry.
I think May 6th probably is full, so we probably have to go to June. I don't know. I may be wrong.
All right. Well, I'm gonna put it on the May 6th because June 6th puts us 60 days into speedy trial.
Okay.
So I realize that's just an backup out of custody date. Likely you guys will see him in a couple weeks based on the sentence that I reviewed, and that will become a moot point. So I'll set that for May 6th at this point. And do you do the 1 o'clock and 2 o'clock calendar, or just the 1 o'clock calendar on that date, Mr. Rosen?
Both. Either
Yeah.
one's fine.
I'll put it at 2 p.m. Okay.
And
So-
then I'm sorry.
So I've added that on the pretrial release order, and then I'm certain there been an order on motion up. So any points of clarification on the motion at this time in my ruling?
No, Your Honor.
And of course, defense, as I articulated, can reserve the right to represent if there's new facts and circumstances that the court needs to weigh.
Okay, is this the time?
Yes. So
Thank
Yes, this is the time to say thank you to Jim Huntsman. Thank you, Jim. Appreciate your support. More wigs and cowbell. I like that idea. I want to have it all. By the way, I hate to pull the plug on us, but I gotta. After this case we're gonna deal with Big Nose tomorrow. I'll get a cowbell, I guess. I already have giant Post-it notes that I'm writing all over. There will be a premiere tonight. I'll say that. There will be a premiere tonight. Yeah, there will be. But let's listen to the end of this case. Look at the guy. Mr. Rosnick looks like he's praying to Jesus. Thank you again, Jim. Oh, and Sashina might have a premiere soon in 35 minutes. I don't know. Donald, I can't tell you that. I haven't even finished the video yet.
I was ordering PR release, but you'd like to address that?
Yeah, absolutely.
Okay.
The reason I'm actually, and this sounds a little, I don't know, backward, I guess, but two things. One, if he's PR'd that he essentially sits in custody longer, it gives them 90 days instead of 60 days to take him to trial. If the court imposes bail, he's held on this matter, which is what I'm asking, something nominal like $100 even. It shortens the time frame to 60 days for speedy trial. And that's a logistic thing. And I suspect Mr. Farrell contemplated that as well, having more time to work on it, notwithstanding that Mr. Orji would be in jail. The other reason, and I'm going to say that this is almost a rule of lenity kind of thing. Fair is fair. Without second guessing the court too much, I suspect had these new charges not been an issue, had these things not occurred and these new charges not been forthcoming, I suspect there would have been a pretty good chance that the court would have granted the motion for release to treatment and a furlough. But they didn't, and I suspect and the court actually made findings which addressed that is part of this, the court's analysis as to why the motion was denied. I think he can't have it both ways. I think if the court imposes some kind of nominal bail, he's going to get day for day credit starting today going forward on these new matters. If the court PRs him, he gets no day for day credit. He's just merely serving out a sentence on another case. I think you can't have it both ways where the court or the city says, well, based on these allegations, we're gonna deny these motions. This is our main argument for why we deny this motion. This is it. This is our strong hand, our strong argument for why we're opposing. And then at the same time, not let them get whatever benefit you get from the day-for-day credit. So I am going to add, and that includes shortening the speedy trial, but mostly the day-for-day credit. So I am asking the court to impose some nominal bail, $100, $500, just so the meter starts ticking. I think that's appropriate. You can't have it both ways.
Was the city objecting to that?
Your Honor, I'm going to reserve. We've made all of the argument I think that we have for Mr. Orjai at this time.
Okay. I'm not necessarily agreeing with everything Mr. Resnick has to say in regards to how the court came to its ruling, or whether one way or another way is fair, because I think they both can be fair. But I'm going to just articulate what I'm going to do today, and without adopting those opinions, but I appreciate the argument, and I will impose a nominal bail of $100 to allow him to, and that will shorten speedy trial, which then of course council can choose if they want to extend speedy trial or not in order to prepare or not. That's up to the parties and the arguments of the parties, but I will set the pretrial for 2 weeks from today, and an out of custody pretrial for later on the, and I believe we got the date, so I'm going to fix that. I think you said it was May 1st.
May
2nd.
6th. Oh, 2nd?
Okay,
Excuse
so
me, Your
that's-
Honor, sorry, my release date for this when I'm being held on is May 2nd. So.
Okay.
I'm sorry, is the question for the court or for your attorney?
I was just addressing the court. I was just letting it be known that with my good time accredited, that my scheduled release date for this matter that I'm being held on is May 2nd.
Okay,
May
we're
2nd.
good. We're good. Okay.
Okay, all right.
One last thing before we pass to the next defendant. And I'm just making a record, and I'll follow this up obviously with paper. Mr. Orjai has instructed me to affidavit Judge Mansfield on this matter.
Okay,
Okay.
all
and
right.
that-
So,
And I just needed to make a record. That's all. Yeah.
okay, and so oh, right, so that's a different conflict calendar.
I'm sorry.
Okay.
Maybe I should have said that first.
No,
instead of
that's fine. That's fine. That's just addressing the out of custody. I think I'm back on the April 26th. Am I not? Can you check? I could check on my phone really fast. if you
I'm
want.
so sorry. Probably should have said that very first thing.
Nope,
but
that's fine. That's part of, you're not the only one that has to scramble with these things. Give me just a moment to check. That way we don't set the wrong date and have to fix it later.
Well, the beautiful thing is we don't have to wait for that. She is checking her phone. I'm sure it's in a pink case. Of course it would be. I've actually really liked the judge. I thought she did very well. I like her back and forth with the lawyers. I like it all. I like it all. 57:15. I hope that you all had a wonderful afternoon. Reminder that we'll have 2 shows tomorrow. We'll have our regular Court Watchers Anonymous meeting on Sundays, Sunday Court Watchers Anonymous meeting, and then we will have our regularly scheduled members only after that. So thank you for being here. Reminder that I love you, I am proud of you, and I will see you in the next video. Bye.